Blast Music247.com. We're changing the industry, one artist at a time.
Hello, everyone. I don't know why I'm always so surprised when I pop up on the screen. Hello, friends. Happy Thursday. It is time again for the Legal Lounge podcast. My goal here is to make everyday things, legal things, understandable, to break them down, to help people understand kind of why things work the way they work, and to give you information to help improve your life, improve things you do. Like last week, I did a class on contracts, just showing people how to read contracts, how to negotiate them, what provisions they're looking for, all that kind of stuff. So I am Nichon Mitchell. I am a licensed attorney. I'm licensed in Tennessee, Mississippi, and my Texas license is pending. I'm also a licensed realtor and a licensed insurance agent. So I try to be a one-stop shop for all of my clients who trust me with the very important things in their life. That way, if you buy a house from me, I can put it in a trust for you. If I do your estate planning, and you need life insurance, I can do all of that for you. And you don't have to go off to all these different places to get important things done. So this week we are talking about criminal law. This is Criminal Law 101. So what I like to do, because I've been an attorney for 25 years, a lot of people watching, and I appreciate it, are my clients and friends and different things like that. I've helped a lot of people for a long time. The other thing with this podcast is I try to bring information that I get asked about a lot. If you have a suggestion for a podcast, a topic, someone sent me a suggestion last week, and I'm getting that material together to put that podcast together for her. If you have a suggestion, please put it in the comments, or send an email, or post it on one of my social media pages, and I will most definitely get something together, because more than likely, if you have the question, other people have the question too. So, alrighty, criminal law. Hope you got your paper, your pen ready. As usual, this is going to be chock full of information, and we'll get started. So I titled this Criminal Law 101, but there's two things. There's criminal law and there's criminal procedure. So criminal law is concerned with the actual laws, the cases and the statutes that say what is against the law, what things you can't do. Criminal procedure is more concerned with the process, like how warrants are executed, how trials are done, how arrests are made, how searches are done. So there's a whole body of criminal law. There's criminal law and there's criminal procedure. Both are very important. I'm going to tell you a little bit about criminal procedure first, because that kind of dovetails into criminal law. The procedure is really what's most important. People probably complain about both equally, the procedure and the law. But so criminal procedure. So we all know that a lot of the law in 49 states, in every state except Louisiana, common law has come from Great Britain. Louisiana is Napoleonic Code from France. So we all know that when the founding fathers put this country together, they put the founding documents together, they did a constitution, but a lot of the people at that time felt like it wasn't enough protections for the things that they came to this land to get protected from, the things they were fleeing from. When you lived in England, the king could send his guards to just search your house without your permission. You could be tried 2 or 3 times for the same thing until they got the result they wanted. Different things like that. So what happened was, after the Constitution was drafted, they put together a Bill of Rights. That's important. So the Bill of Rights, those are the first 10 amendments to the Constitution, the first 10. And what the Bill of Rights does is it limits the power that the federal government has in relation to the American people. It limits what the federal government can do to the American people. I point that out because the importance is it doesn't limit what the states can do to its own citizens. It's two different things. So with So that was somewhat always a problem, that the Bill of Rights only protected people from federal government action, not state action, until the 14th Amendment came along. And this is all getting somewhere to what you all are going to want to hear. So hang on. I know this sounds a little nerdy, but you need to know this part. So the 14th Amendment comes along in 1868. It does a lot of things, like incorporate the 13th Amendment in, which freed the slaves and told the states you can't do slavery anymore. The 14th Amendment, though, has something called the Due Process Clause. Now, I talked about the Due Process Clause in some of my other podcasts because this is a very, very important amendment, the 14th Amendment. And it actually makes the principles in the Constitution applicable to the states, because it says no state shall deprive any person of life, liberty, or property without due process of law. That's why it's called the Due Process Clause. Due process of law infiltrates every single thing we do. Like if you have a driver's license and they're going to take your license from you for whatever reason, you're entitled to a hearing because of due process. If you're a state employee and you're about to lose your job, you're entitled to a hearing. Anytime you're about to be deprived of life, liberty, or property, you have to get due process. So that's the only reason why, though, is because of the 14th Amendment. So there's this debate in academia about how much does the 14th Amendment really incorporate from the Constitution. This debate about how much of the Constitution does the 14th Amendment incorporate it so that states have to give people rights. This is important to you on the everyday level because that's the discussion about police force use against its citizens. How much police force can a state authorize against its citizens? So how much the 14th Amendment incorporates the Constitution into the states is important because it affects the powers of states to regulate the lives of their citizens in terms of how much contact they have with the police and stuff. So that was kind of nerdy, but it was important for because these are the bigger, broader issues that when you have time, you want to know more about when you're watching the news or watching social media or anything about qualified immunity and the police and how much power the police have. You want to know in the state you live in, what's their theory about the 14th Amendment, how they cope. That's where all of this is coming from. It's not just a surface level discussion. It's a much deeper discussion. And that's why I wanted to bring this up. We definitely don't have time to cover it here, but you will know there's more to the issue than what meets the eye on the surface, and you'll want to look into that. So now, in terms of the Constitution, what I'm saying, I'm just going to highlight a few points and I am going to move on to the criminal law part of it. We're going to talk about actual crimes, what the technicality of what a crime is, how you prove it, and how you defend against it. We're going to talk about those things. Okay. So the biggest thing, okay, so you guys, I used to be a prosecutor. Okay. So the biggest thing that I want people to know is consent is actually it's a real thing. You know how people say no is a complete sentence? No is a complete sentence when it comes to consent. Generally, you don't want to just give consent. Ma'am, can I search your vehicle? No. Ma'am, can I search your home? No. Make the police or whoever it is, make them get a warrant. They want to search something, make them get a warrant. Quick break to say hello. Hey, Cindy. And hey, my son's watching. My baby's going to be 30 this weekend. Hey, CJ. Hey, Cindy. Okay, I'm sorry. I saw those highs and wanted to say hi. Okay, so remember, your consent can be freely withheld. It's your right as an American citizen. And on that note, I want to encourage everybody to have their own copy of the Constitution in their house. Now, I got this book from Five and Below, of all places. You don't have to have some expensive official version of the Constitution. This is the Constitution and a lot of the founding documents and different things like that. But it's American to say, no, you can't search my house. No, you can't search my car without a warrant. That was what they came over here for. That's what they established these documents for. And all the time I see, they say, can I search? And then the person say, well, yeah. And that's where the problems come. So I would encourage you, if you don't have an attorney on the scene, if you don't have anyone else there to competently help you protect your rights, if a police officer, if they want to search something, just say no. I wouldn't say no, get a warrant. No is a complete sentence. Say that. Um, Another quick tip, and I'm throwing tips out. We might circle back around to address them, but I always run short on time, and it's things I want to make sure I get out. If if a police officer has an arrest warrant to arrest somebody, they cannot enter your home or a third party person's home in order to do it. So there's a couple of exceptions to that, but the general principle is an arrest warrant and a search warrant is two different things. And they have to have a search warrant to enter your house in order to arrest the person, unless there's exigent circumstances. Like they have an arrest warrant, they knock on your door and say, "Is so and so here?" And you say no, or you say, "I don't know." But they see in the back, I'm so and so is John. They see in the back that John is holding someone hostage with a knife to their throat. They're gonna come in, something like that. But just generally speaking, what people should know is an arrest warrant and a search warrant is two separate things. And so, since people don't know, the police will show up, knock on the door, and say, "We have an arrest warrant for so and so, and we're coming in to get them." No, so no, sir, you're not. So that's something to get more information about and be aware about. And of course, always have an attorney that you can contact so about different things like that. Okay. I have next in my notes to talk about deadly force to make an arrest, but I may want to hold that. No, let me just go ahead and talk about it. Okay, because it kind of falls under criminal procedure. So look, I told you earlier about the 14th Amendment, and that discussion is important because it regulates kind of how states um, give their police guidance on how to interact with the citizens within their borders. Okay. So, deadly force to make an arrest, we all know about these cases in the media where police officers are shooting citizens in order to make arrests. So, what you should know is, and kind of what we all have a sense of, even if you haven't gone to law school, is generally you can't use deadly force to arrest someone or to even prevent their escape. This is why a lot of times, and I watch with a lawyer's eye. When I watch shows like FBI and Law and Order and different things like that, I'm watching through a lawyer's eye. But a lot of times they'll say stop, and the person keep running, and they let them go because you have to let them go. They can't use deadly force to effectuate their arrest unless that person is getting ready to be in immediate danger to the police or the people around them. So, all of this shooting people while they're running away, shooting people who otherwise were not dangerous, like if they committed the crime of trying to break into a car, the police come up, they see a guy yanking on the doors, they say stop, and he just takes off and runs. He's not he's not presenting anything to show that he's dangerous. You have to let him go. You can't just shoot him because you saw him trying to take a car. So you the officers have to have a reasonable belief that he's getting ready to be an immediate harm to either them or the people around them. So that's an important note. And then, so remember I said procedure is about how things are done. And the other reason I'm giving these tips is just in case you need to know this information. There's a lot of technicalities. You should always get with a lawyer. Like one interesting little factoid, like in Mississippi, is when a person is indicted, the indictment is not effective if it doesn't have the last sentence that says that the person committed the crime against the peace and dignity of the state of Mississippi. If that line is left off, the indictment is no good. You want an attorney that knows that, because I'm all about fighting on the technicalities. I'm gonna fight on every single issue I can fight on for my client. So sometimes that's missing. And if it's not on there, I'm gonna move to dismiss that indictment because it doesn't say against the peace and dignity of the state of Mississippi. So my point to telling you that is there's so many little kind of different things that need to be known in the criminal law, criminal procedure realm that you want to make sure you have a good attorney to help address those issues. Now, that being said, let me say a word real quick about public defenders. Public defenders get a bad rap, and people have said all kinds of things about them. Um, Public defenders are lawyers. They have gone to law school. They have to pass the bar exam, just like all of their lawyers. They just, for whatever reason, they're in the office. Some of them actually want to be there and do this type of work. Some of them is where they start, and then they build themselves up and they go start their own practice, whatever the reason is. But their workload is insane. They could have between 250, 300, 400, 500 clients, depending on what city they're in. So, um, just because someone has a public defender doesn't necessarily mean they have a bad attorney, or that that attorney is not a good attorney because they're a public defender. A lot of times is they are severely overworked and they can't give each case the time and dedication that they need. That's a true statement. It doesn't mean they're any less smart, any less anything else. It just means they don't have time. And it's because the system is just so clouded. Let me get this question real quick. What about the recent situations that the fleeing citizen is in a car and drives near, away, and deadly force is used? Yeah, that's the analysis that you're seeing when, like a lot of the news outlets, the reporters will say, were the officers in danger of being hit by that car? That's why they're showing the body cam so that we can see from their perspective what they saw. So could it be reasonable for them to think they were about to be hit or killed by that car? Um, that's the kind of analysis that has to happen. So if when these people are getting in the cars, though, they should say stop police, stop police. But if the person doesn't stop, a lot of times even the policy and the protocol is to let them go, because guess what? They have about 10 other police cars and they could have gave chase. They could have done that. They didn't have to shoot into the cars. So that's a really good question. And that's what that's about. The officer still has to feel like, usually, now what we need to know is a car is considered a deadly weapon. A car is considered a deadly weapon. Generally, if you aim your car at an officer and you're headed in their direction, 9 times out of 10, a shooting like that is going to be upheld depending on how it's done. But the general overall is a car is a dangerous weapon. And if you aim it at police officers and you're going in that direction, they're going to shoot you, and most likely it's going to be upheld. A lot of these instances, though, where officers stepped into the danger or officers were on the side, they were not in danger and they still opened fire. They can't do that. So those are supposed to result in indictments. They're supposed to result in trials. We'll see what happens. The other thing is, back to the point I made earlier, now these are federal officers we've been talking about lately that's been doing this. But remember I said that tug and pull between the federal constitution and the states' rights and how they can have their police officers interact with their citizens. So there's that tug and pull again. And then that's why states too, a lot of times have a choice of saying, we don't want the federal officers in here in our sovereign borders. So it's really a bigger issue than one we can discuss here or two that's been kind of put out in the media. But a lot of times when it doesn't make sense to lay people watching the news or watching different outlets, it's because nobody's breaking down the behind the scenes constitutional considerations and the back and forth pull and tug between federal rights and states' rights, which, side note, you'll hear Republicans and Democrats talk about in their platform. This is why elections matter and all issues are important. We should research these things because how much states' rights and how much federal rights exist matters to you on a day-to-day basis. And this is one area where it matters, how the police can treat you in a certain state wherever you live. So I'm going to move on quickly. Hey, Miss Brenda Powell's on. Hello. Okay, let me move on to actual criminal law because I want to tell you the basics about criminal law. We have just been talking about procedure, and I wanted to cover procedure really quickly because that kind of lays the foundation, the Constitution and searches and warrants and all that kind of stuff. It kind of lays the foundation for how things are done and how the law is implemented. So the criminal law. So what is a crime? Let me just say it this way. A crime is composed of two different things, an act and a mental state. So you have to have either an action or the failure to do an action, either action or inaction, and a mental state. Those two things together, depending on what the act is, will determine what the crime is. So the basis of all crimes is an act and a mental state. So many crimes are based on a legal duty. So a lot of the offenses, crimes that people are charged with, they are based on a legal duty. For instance, let me check my notes here. Okay, so like a statutory requirement. So there's a statute that says you shall file your tax return every year on the 15th of April. If you don't do that, we all know that's tax evasion. It's a statute. So that's like a statutory creation of a crime. There's a contractual relationship that can create a crime, i.e., example, if you're a lifeguard for the city and you are employed and you sign up to be a lifeguard and then you go work, you contractually agreed to take certain actions. So if someone falls in the city pool and then you don't jump in to get them, that could be a crime rooted in negligence that you can be charged with. Your status in a relationship can be the basis for a crime. In other words, your status as a parent. If you have a child and you don't know where that child is, that's a problem. Everyone remember the Casey Anthony case in Florida when she had a 2-year-old daughter and the daughter just went missing. And she was like, oh, I took her to the babysitter and I don't know where she went after that. Let me tell you about Florida real quick. Where they messed that up, where those prosecutors messed that up is they charged her with murder. They charged Casey Anthony with murder for her 2-year-old daughter going missing. They overcharged that case because it's already a crime to not know where your child is. As a parent, you have a responsibility to care for that child physically, emotionally, everything. You have a legal duty to care for that child. You breach that duty when you don't know where the child is, and there are statutes for that. They should have just charged her with neglect of a child. And while she was in jail for that, further investigated the murder case, and they could have built a better case against her and won it that way. That's what I would have done if I was the prosecutor. The prosecutors in Florida are losing a lot of cases because they tend to overcharge, is what I'm noticing in the cases. And sometimes you just have to go for the win that you can get based on the crimes. And I'm getting ready to go through a lot of the crimes in a minute. You'll see what I'm saying. But based on what the crime is, sometimes you can only, win at a certain level. You can't go for the gusto. Everybody think, yeah, watch this. She probably killed her kid. That's not going to get you with the jury. Probably killed her kid is not going to get it. So they should have charged her with what they definitely could have proven. They definitely could go to court and prove you have a child, she's under the age of 18, and you don't know where she is. That's what they should have done. Okay. Look at that. My son, he says mens rea and actus reus lives rent free in my mind because of my mom. Correct. So if you guys can see that comment, mens rea is actually the Latin word for mental state. Is actually what state of mind is a person in when they do something. So right now, you saw always say the kids do something. What are you thinking? What were you thinking when you did that? Right. So, okay. So remember what we've said is you got to have an act and a mental state. There are several different things that can be the basis of a crime. And I left out if you take responsibility for something, like if you're just a regular person, you're not a lifeguard, and you say, oh, go ahead and swim. If you fall in, I'll come get you. You set yourself up for a crime if you don't do it. And if you do something that creates the danger that then hurts somebody, you are in a position to be charged with a crime. Like we're standing around a pool and we're all laughing, and say it's me and somebody else, we standing around the pool and they push me in. I am not the best swimmer. I might be able to doggy paddle to save my life, maybe, but I drown because they are joking around. They pushed me in. They created the peril. which was pushing me into a pool and I can't swim good enough to save my life at least. and and then they either failed to come rescue me, or by the time they rescue me, I've taken on so much water that I die. So if you create the peril, you are also setting yourself up to be in a position to be charged with a crime. Okay, so these are the mental states that need to exist in order to be charged with a crime. And I point these out because every statute that says what a crime is going to tell you what the mental state is that the person had to be in order to be guilty of that crime. If that person didn't have that mental state in the statute, they can't be guilty of that crime. I point that out because oftentimes that's where a good defense lies, is in the prosecution has to prove that I had a certain mental state. They may not be able to do that based on the facts and circumstances of the case. So, one mental state is a specific intent mindset. So, when it's specific intent, the prosecution has to introduce some independent evidence of what the defendant intended, and it can't be inferred from his conduct. So, there's a shooting between a husband and a wife. The wife shot the husband. You can't infer just because she shot him. You can't be like, well, she had to mean to kill him. She shot him. You can't infer somebody's intent from their action. The prosecutor has to be able to prove the specific intent from some independent information, like a witness will call in and say, oh, yeah, she meant to kill him because she sent me a text last week that said she was sick of him and she was going to shoot him. Okay. That would be independent evidence outside of the person's conduct that would prove their mental state, their state of mind. But what if something like that doesn't exist? If the prosecution can't prove the state of mind that's required for the crime, they can't prove the crime. So one is specific intent. The second mental state, possible mental state that can exist, is malice. There's another one called general intent. So remember, the first one I talked about was specific intent. With general intent, you can infer that from somebody's conduct. And then there's strict liability, which you're liable for that. Strict liability crimes, no intent needed, you are already liable for that. So a lot of times, so the mens rea, like my son said, the mental state, a lot of times that's talked about in the statute is purposely, knowingly, recklessly, or negligently. Now, I'm going to read a few examples of how the statutes read, and so you'll get an idea. You'll get an idea of what I'm talking about. I'm reading from my Mississippi Book of Crimes when I was a prosecutor. And I will tell you, okay, so like receiving stolen property. A person commits the crime of receiving stolen property if he intentionally possesses, receives, retains, or disposes of stolen property, knowing that it's been stolen, or having a reasonable grounds to believe it was stolen. Now, let me tell y'all about receiving stolen property real quick, because I get calls about that. And let me tell you how they get you on that one. First of all, it says if you intentionally possess the property. So you don't have to know that it was stolen. Intentionally possess means just that I have it. I am intentionally possessing this book. I have it. Okay. It doesn't mean intentionally possess knowing that it's stolen. It doesn't mean that. It just means the fact that I have it. The other part of the statute that gets people is that you either have to know it was stolen or it says have reasonable grounds to believe it has been stolen. What the case law says about that is if you got something and the price was just too good, the law imputes upon you that you have a reasonable basis to know it was stolen. So if someone is selling me a car and it's a 2024 Cadillac, let's just say it's an Escalade, because we all know those are very pricey. If someone sells me a 2024 Cadillac Escalade for $20,000, the law is going to impute to me that I should know that's stolen. Okay, that's why maybe an estate is selling it because they want to get it off the books or something. You better have some really good information or proof about why you're getting something of that value for such a cheap price. That goes for Rolex watches, that goes for coach purse, any purses, any jewelry, anything like that. If you are buying something at an exceptionally good deal, especially from a single person, and it's not a store, you're not walking into Walmart or something, you better get some really good information on where it came from. Because I've seen them prosecute this because they're trying to crack down on the fake bags and stolen cars and all the stuff that's going on out there. And that's why they wrote this the way they wrote it. Intentionally possess, receives, retains, or disposes of. They're going to hem you up. And then it says that you know it's stolen or you reasonably should have known it was stolen. Okay, I'm not going to beat that one in the ground because I got others I want to read so that you can see what I'm talking about this. Okay, let's arson. This is arson of insured property. Any person who willfully and with intent to injure or defraud the insurer sets fire to or burns or attempts to do so. So you see how this one said willfully and with intent. The other one said intentionally. Um, Aggravated assault upon a firefighter. Any person or persons who willfully, feloniously, and maliciously set fire. See, now look, prosecutor got to prove all that willfully, feloniously, and maliciously. The prosecutor got to prove all that. So, those words, when you see them, knowingly, recklessly, intentionally, those go to state of mind. And state of mind can be difficult to prove unless there's direct evidence. Now, I'm going to take this opportunity to talk about direct evidence and circumstantial evidence. I'm going to answer these questions and then we're going to take our quick music break. Okay. Direct evidence. Let me give you a good definition of it because direct evidence. Proof that directly establishes a fact without requiring an inference or presumption. It immediately proves the point, like a video. So if there's video, like they just in the news, I don't know if y'all saw the guy that worked at Kimberly-Clark factory. He set the whole factory on fire because in the video, he said he started with a little pack of toilet paper. He set it on fire. When I tell you, they said that facility was 11 blocks long. When I tell y'all the whole thing burned down, when he set one pack of toilet paper on fire, Kimberly-Clark, y'all know they make toilet paper, paper towels. I think they may be the maker of Charmin or something like that. The whole thing burned down. But on the video, he said, all y'all had to do was pay us more. And he set it on fire. Okay, that is direct evidence. Now, what if there was no video and they went in and did an investigation and they found his ID lanyard? They found one of his shoes by the scene. They had all these little bitty pieces. And if you put it all together, the indication is it was him. That's circumstantial evidence. When you have to take pieces of evidence and you have to make a logical leap or you have to make an inference from that piece of information, that's circumstantial. Now, there's a saying in the law, circumstantial evidence does not make a case, but you can cobble together so many pieces of circumstantial evidence that you can get a jury to beyond a reasonable doubt. And sometimes this is what happens to people and innocent people. All these little pieces of circumstantial information get cobbled together and a jury gets swayed that someone is guilty. Let me read this question. How does this work for marketplaces like Facebook, Craigslist, stolen good? Pretty much the same way. Stolen good. Yeah, pretty much the same way. If you're getting something off of there, a lot of times people do put stuff on there for really good deals, but that's why I said you got to do your due diligence, do your investigation. Make sure you have the person's name, address, phone number that you got it from. You have to be real detailed about that because a lot of times people do get fake or real purses, jewelry, whatever this, that, and the other, and they put it on those platforms. But you just have to be really careful because if you get an ambitious prosecutor who want to make a case, they want to get on TV and put a whole table of stuff, say, we recovered all of this and we have 40 indictments pending. You're going to be one of them indictments. So it happens every day of the week. You have to be careful with that. So normally what happens at the midway point is we take a little bit of a break. This is going to be about a 3-minute break. We're going to play a music artist. That's the time to grab a drink, go to the bathroom, develop a question. Please put it in the chat. If this is going well for you, if you guys want to let someone else know to join in, so, that's the time to do that. So we'll take a little break. When I come back, though, I'm going to talk to you about more crimes. We're going to talk about larceny, burglary, and also defenses. How can you defend against, the defense of insanity, of intoxication, infancy? We're going to talk about self-defense, stand your ground, and different things like that when we come back from the break.
I know you're telling me you need me, but I done heard it many times before. Broken hearts ain't easy. They're playing all my insecurities for sure. Now everything seems like a lie, and I just can't get it out of my head. My friends telling me I gotta try. Baby, I want to, but my heart won't let me love you. Love you. Love you. Trust when I say I want you, my heart isn't there. Love you. Love you. Love you. It's not you, it's all me. Nobody can get in. I've been scarred too many times. Every promise leaves a bitter taste. Been asking me for all my heart, but there is nothing left to give away. I wish the pain would let me fly. These wings are broken. You say you wait, but I don't know why. My soul feel lost, I feel like I'm losing. Love you. No me dejas. Love you. Es que no puedo. Love you. And trust when I say I want to, my heart isn't there. Love you. It won't let me. Love you. It's not you, it's all me. Nobody can get in. Tengo demasiado miedo de dejarte entrar. Tal vez algún día seré libre, pero ahora amar se siente como un pecado.
Hey, okay, we're back from the quick break. And so, guys, what I'm referring to, I have notes, but I also have this book, which has this was my Mississippi criminal manual that I used as a prosecutor. Has all, look how thick it is, y'all. These are laws, these are criminal statutes in here, okay? And I point that out to you just to say that there's a lot to know and there's a lot of laws. I put in the comments because I didn't want to forget to tell you all. I get calls also, several calls where parents call about their kids that have gotten in some trouble. The kids are 18, 19, 20 years old, even up to 25. And the parents will say to me, oh, well, they're just a kid. I want to tell everybody out there, when you get 18, it's game over. And a lot of places, when you 16 and 17, it's game over because they're going to push it to adult if you got that kind of prosecutor, okay? So we need to stop saying they're just a kid. When our kids get, especially kids in our minority communities, when they get 12, 13, 14, 15, we need to prepare them for this time at 18, when if they do something silly that may be kid games or stealing a car or joyriding or something, but it's actually very dangerous, especially because, as we've established, these officers are shooting first and asking questions later. We need to prepare them for the fact when they get 18, they are 100% fully accountable for the actions that they take. So we need to move away from, oh, well, they're just a kid, because plenty of prosecutors out there don't care about that. And a lot of communities don't care about that. They're going to prosecute your 18-year-old just like they're a 40-year-old and should have known better, right? So, okay. Oh, and then I wanted to share something very interesting. I ran across this when I was a prosecutor. Now, this statute has since been repealed, but they didn't repeal it till just like 2018 or 2019. So, 8 years ago. But for the longest, this was on the books. So all of us out here with grandmamas that's funny. They used to talk about somebody and they say that girl is a tramp. Mostly we associate the word tramp with a female, but technically in Mississippi, when I was a prosecutor, this was the law. And until 2018, let me tell you what a tramp was. A tramp is a male person over 16 years of age and not blind, who shall go about from place to place begging and asking subsistence by charity, and all who stroll over the country without lawful occasion and give no account for their conduct consistent with good citizenship shall be held to be tramps. So, and then the next statute said, any person may arrest a tramp and take him before the justice of the peace, who shall at once take the affidavit of such person charging the offense, and shall then try the accused as being a tramp and deal with him accordingly if found guilty. So, who knew a tramp was a man? And so I always thought that was an interesting little fact. And I just thought I would share that with y'all because if you actually read these statutes, you'll figure out something you didn't know. And then on a little bit more serious note, this is why if you know older men, especially in the South, so I'm 52 now, so probably 60 or over, they will tell you they didn't leave the house without money in their pocket. And a lot of times too, if the police would stop, they even do it today. Hey, where are you going? What is this? Because, and I told you this just got taken off the books, 2018, 2019, this just got taken off the books. But the police stop you and they ask you where you going and you not going nowhere in particular. You ain't got no money in your pocket. You ain't got nothing. You could be arrested if you're a 16-year-old male as being a tramp. There's still a lot of these little laws are on the books, or until recently they were on the books. That was an opportunity to take someone into custody. So while it's a bit humorous and a little funny that a tramp was actually a man, those laws were actually also used as a way to oppress people, as a way to lock people up, as a way to deal with a certain class of people. So alrighty, now look, how do you defend against these crimes? And probably what I should do first is, okay, let me talk about offenses and lesser included offenses. Let me give you an example. So you know how somebody is charged with something or somebody goes on trial and they say they pled guilty to a lesser included, or they were convicted of a lesser included offense. Let me tell you where prosecutors mess up sometimes. And this might be good for you if you're a defendant. It depends on the strategy. Remember when I said that Casey Anthony got overcharged? They charged her with murder. They charged her with murder, but they didn't charge her with anything else. So I agree with the defense. I wouldn't have said anything either because they couldn't prove the murder. But a lot of times what prosecutors will do is they'll charge you with murder and then lesser included. So murder and manslaughter, and they'll go down like that, right? Murder, manslaughter, and attempted murder. They'll try to cover the whole gamut. Burglary, larceny, theft, kind of like that. So that way, if they can't get you on the main thing they want to get you on, maybe those facts equal one of the lesser included offenses. Now, why are they called lesser included offenses? Because really offenses build on each other. For instance, let's talk about larceny. Let me tell you another thing that people get wrong. Okay, people think assault is an actual hitting. People think assault is like this, it's touching. I was assaulted. That is not what assault is. Assault is when you put somebody in fear or apprehension of bodily injury. So, and I've been told apparently I'm a scary person. I don't think I am, but okay. So, my son is on here. He'll get a good kick out of this. When they were kids, if they were just out of line and not really him, but sometimes kids get a little rowdy. And I grab them up and I say, do you value your life at this moment? Right. And their eyes would get big and they would look at me. I haven't done anything, that I didn't spank them, I didn't hit them, I didn't do anything. I would just say, do you value your life? And so as they got older, I come to find out that really scared them. They were terrified, right? That's assault. Now, once I actually spank them, that's a battery. That's a hitting. But I don't get charged with that because as a parent, I'm allowed to implement corporal punishment on my children. That's in the statute, right? So that's why. Now, what I'm not entitled to do is actually injure them badly, but you can inflict a good amount of corporal punishment on your child. That was a side note. Okay, so a battery is a completed assault. That's it. So the assault was, I put you in fear or apprehension of bodily injury, and the battery is, I actually did the bodily injury. That's why it's assault and battery. You can just assault somebody. You can just batter somebody. You ain't got to say, you can just walk them to them, bam, and just cock them. It's just a battery. Okay, right? So I wanted to clear that up because a lot of people think assault is actually being physically attacked. It is not. It is someone putting you in fear of the fact that they're going to hurt you. So let me go to larceny, because that's the one that I think will make it clear. So larceny is the wrongful taking of something. Basically, you stole it, right? Except for, this is the other important thing to know about crimes. If you charge with a crime, there's something called elements. And an element is every little piece of fact that the prosecutor has to prove in order for you to be guilty. They have to prove every single one beyond a reasonable doubt. Not a few of them, not a couple of them, not most of them. Every single one individually beyond a reasonable doubt. So a larceny is the taking that's wrongful, and you remove the item away without the owner's consent, and you intend to deprive them of it permanently. Look at that. That's 5 elements. If they can't prove you took it, or that it was wrongful, or that you carried it away, or, you can't, prove I stole something if I'm still standing here with it, right? You can't charge me with larceny. Now, side note, that could be a conversion, but it's not larceny, right? So I point that out to you because it's important to know, like, we just use these words like theft, murder, this and that, but that word actually means, it has a definition in the law that has to be proven completely. So you have a larceny, right? Say that, say that I had a taking, it was wrongful, I carried the property away, I did it without the owner's consent, I intend to deprive them of it permanently, I put them in fear while I was there, and then I did it with a threat of violence, or I used violence. That's a robbery. So larceny is a lesser included of robbery. So you see how robbery just built onto so basically robbery is a larceny and an assault at the same time. That's what a robbery is. Then you start getting into aggravated robbery, where they used a weapon or they tied the person up or something like that. So that gets, it still builds from there. So then it's aggravated. Now you added a gun in, or it's aggravated because you robbed a child, someone under 18, something like that, right? So these are what lesser included offenses in. Now I'm telling you about that because they might charge you with, say like they charge you with a robbery. And even if they don't charge a lesser included or discuss the lesser included, you can still plead. You can say, hey, I want to plead to a lesser included if you want to plead. But you could just remain quiet and say they can't prove a robbery because they can't prove there was any violence. So it's a lot of overeager and overly aggressive prosecutors out there that want to go for the gusto. And there are some prosecutors, a lot of them that care about their conviction rates and stuff like that. So it's important. This is a lot of times the stuff the attorneys don't take time to explain to the clients how this actually really works. And so clients get frustrated and they get upset and they say all these things about attorneys because attorneys are not great communicators and they don't say all this part. My clients trust me and I have a good client base because I actually take the time to explain this stuff. And I tell my clients, look, this is how this works, because I got to manage their expectations and I got to let them know how I'm going to do the best job for them that I can do. I have to tell them how it works. They have to understand it. So I am a great communicator at talking to my clients and saying, hey, this is how things work in the criminal process. But a lot of attorneys are like, basically they're like, sit down and shut up kind of deal. And so people never get a complete understanding of how the process works and what the law is. Remember, we started this whole thing out by saying there's criminal law and there's criminal procedure. And attorneys don't do a good job at explaining the law and explaining the process. This is why you can't use self-defense in this instance. This is why you can't tell the court this part of the case. It's hearsay, or it's not corroborated, or it's circumstantial evidence, or what, and they don't take the time to explain that. So that's why people end up feeling the way they do about their encounter with their attorney and the legal process. So since I've explained a little to you about, okay, so murder and manslaughter, right? So murder is definitely a specific intent crime. Some states break murder down and they say murder 1, murder 2, murder 3. And some states are just like murder, manslaughter, voluntary and involuntary manslaughter. They break it down that way, and they don't have different degrees of murder. So I think murder might be a good way to talk about stand your ground and different things like that. Let me real quick tell y'all, though, some defenses to these crimes. Of course, insanity is a defense. Now, look, you can say insanity depending on what state you are in. That depends on how the test for insanity is given. What is the legal standard to say, yes, this person was insane when they committed that crime? There are different theories and views on how to gauge insanity. You need to know what state you're in and what their view is on insanity in order to know if that's going to be a viable defense for you. I mean, of course, if you were really crazy, you were really crazy. But still, just to let you know that it's not just as easy as saying insanity. You have to meet a test for insanity. Intoxication can be a defense, whether voluntary or involuntary. What is voluntary intoxication? I had too much to drink when I accidentally pushed Nichon into the pool. Okay, remember I said you liable if you create the peril. But if you were intoxicated because you had too much to drink, that's a defense to the crime. Involuntary is a roofie in your drink, or something like that, where you didn't intentionally ingest it, but you became intoxicated. Infancy, really meaning, remember I said they'll try to get you at 16 or 17 for an adult in some states, but if you 14, 13, 12, those ages, that's why they go to juvie. That's what that's about, because the defense to the crime is their infancy. They are under the age of majority. Self-defense is a defense to a crime, but you have to have the right to exercise the self-defense. There's deadly force and there's no deadly force in self-defense. Let me tell you where stand your ground came from. At common law. Common law in this country is, for lack of a better way to say it, what the law commonly was. It's not statutory. It's not codified anywhere. It may be recited in the case law, but it's what the law commonly is in America, in this country. In this country, way back before people even got to this country, started in England, came over here, the common law was you had to retreat from a dangerous situation. So that was always very foreign to me. I'm going to tell y'all, 6:54, we may go over 10 minutes, okay? That was always very foreign to me, that you had to retreat. This is all based on how we grew up, right? The people know me know I'm from the south side of Chicago. I'm from Allgale Gardens. You better not go home telling your parents you ran from a fight. You better not do it, okay? And so when I'm in law school, 23 years old, sitting there, and they talking about you got a duty to retreat. I'm like, run? Oh, no, we don't run, but yes, we do. The other thing that was striking to me was that if you are in an altercation, you cannot exceed the amount of force that's being brought against you. Have we all heard the term that says somebody brought a gun to a knife fight? That's kind of where that came from. You can't exceed the amount of force that's being levied against you. That's why I was like, so in law school, I was like, well, how am I supposed to win if I can't exceed their force? What you're supposed to do is create enough distance or space between you and that person So say I'm in an altercation with somebody and I'm able to shove them off, they lose their balance and fall back. That's when I'm supposed to run. I'm supposed to retreat from that situation. Okay, so at common law, you never had to retreat from your home. If you're at home and someone breaks in, assaults you, attacks you, you don't have to run from your own home. You always had the right of deadly self defense in your home. Okay, so where this became an issue is if you just out in public and out in the world and someone attacks you, you had to retreat. Well, a lot of states didn't like that. So they passed a law that said you do not have to retreat from basically a public place. You do not have to retreat in order to defend yourself. That's what stand your ground is. So basically, if I'm at the 7-Eleven and I'm pumping gas and somebody starts to accost me and attack me, I don't have to do what I just say, create this distance, run away, do this. I don't have to do that. I can stand my ground right there and defend myself with deadly force. That's where stand your ground came from. Now, side note, I want to talk about Trayvon Martin real quick because a lot of people was mad at me when that case was going on because I told everybody George Zimmerman was going to get off. I was following the evidence. I watched it closely. I want to explain to you guys why. It fits right here in this thing. So everybody was upset about that case because George Zimmerman was following Trayvon. The 911 operator told him he didn't have to follow him. The 911 operator said, let it go, leave it alone, this and that. All of that is true. But when the trial came, the trial was not about any of that. And so what happened was, I can't remember if he was charged with murder or manslaughter, but his defense was self-defense. That's what George Zimmerman's defense was, self-defense. And let me tell you why. If you all remember the fact pattern, remember Zimmerman was following him. Trayvon was like, quit following me. And then eventually it ends in an altercation. They were fighting. Trayvon Martin got the best of George Zimmerman and got on top of him and was punching him and banging his head against the concrete. At any point in time that you are in an altercation, there may be a slight side note of if you started the fight, but I'll come back to that. Okay. If you're in an altercation and you are in a reasonable fear that your life is about to be taken, you can use deadly force to protect your life. So at the point that Trayvon Martin is on top of him and banging his head against the ground and punching him and basically getting the best of him, George Zimmerman, at the point your head is being banged against the ground, you do have a reasonable fear that your life is about to be taken. So at that point, he had the right to exercise self-defense. And unfortunately, but I had to explain to people, none of that other stuff mattered. At the point that George Zimmerman was in a position that he was about to lose his life, he had the right to exercise self-defense. And that doesn't mean that I agree or condone it or anything like that. People think that means I sign on to it. I'm just telling y'all what the law is. Do not shoot the messenger. I'm just telling y'all what's in all these books that we got, what's in all this stuff that we have around here. I'm just telling y'all what's in these books and how it works. Okay. So that is why the George Zimmerman case turned out the way it did. So I said all that to say, you have a right to protect your life. If you are in reasonable fear that your life is about to be taken, you can exercise deadly force in that moment. You can also exercise deadly force on behalf of someone else. You can exercise the amount of defense they would have to defend themselves. So say a woman is being attacked, she's being beat up and her life is about to be taken. She doesn't have a gun. You have a gun. You can defend her and exercise the same amount or the same right of self-defense that she would have had. You can't exceed what she would have had, but you can exercise it for her. That's another defense. So if they want to charge you with manslaughter, murder, whatever it is, aggravated assault, because you shot the guy, your defense is called defense of others. I was defending someone else who had the right to exercise self-defense, but for whatever reason could not do it, and you chose to do it for them. Let me see. I think I have gotten to the end of my notes. Let me see. Right. Do not shoot the messenger. Thank you very much. Please don't. Let me see if I see any questions. Don't think I see any questions. We still, I can hang on for a few more minutes on here if we do. Want to remind you guys if this was helpful, let me know. Please give me feedback. Like I said, my goal is to bring common issues to the attention of people. And of course, let you guys know I'm here. My information has been scrolling at the bottom. You can text, call, you can use my Calendly link to set up a 20-minute consult. And a lot of you that are on here already have my number. I appreciate all of my loyal watchers. Cindy, my friend Cindy Triplet watches every week. Thank you, Cindy. Thank you to our sister Camille who watches. My mother-in-law, Gloria Mitchell, is the best. She's ultra supportive, and I really appreciate that. I want the podcast to take off because I really want to help people with a lot of the common everyday legal issues that people have. I want to just bring awareness. And next week, I'm working on a few special podcasts. I'm working on long-term care episode where if you have a family member that needs to go into a facility, then I'm going to have a guest on to help navigate all the things that need to happen when your family member has to go into a facility, which would include you need to get a power of attorney and get their documents in order. I have an aunt in a facility with me here in Dallas right now. Me and my brother have a power of attorney. We help manage her affairs, different things like that. So that's something that I know people need help with. How to put your loved one in a facility, facility where they can be cared for, and what things you need to consider. I'm going to have an episode on budgeting and financing for people. I'm going to renew my episodes on trust, wills, and estates. I'm going to renew my episode on home ownership. That's something we need to increase. There are some programs that I saw today that could be helpful. I want to help increase home ownership. So all of these shows are meant to provide you guys, to make the legal stuff a little bit easier to understand. Question: carrying a legally purchased weapon across state lines. Ooh, that depends on what state you're coming from and what state you're going to. And that's why it's a good thing to actually research that. Some states, there's no way to get straight from Tennessee to Texas. If there was, you'd be good. They're both, open carry, no license. But sometimes, like in Illinois, the weapon has to be in the trunk. The ammunition has to be separate from the weapon. You have to know the state you're going from and the state you're going to. You're gonna have to look that up and see, what the law is in the state you're traveling from, the state you're traveling to, and really any state you're going to be traveling through. You need to know, can the gun be in the glove box? Does the ammunition need to be separate? Does the gun have to be out of the reach of the driver? All of those things you need to know. And that's just about doing your due diligence and your research before you travel. And it's worth doing just because the political atmosphere we're in right now, you don't want to give them, I say this every week on my podcast, don't give them any reason to mess with you. None. Don't give them any reason. So that's how you deal with carrying across state lines. It can be a federal violation, of course, because you're crossing state lines. The feds may decide to leave it to the state and let the state prosecute you, depending on why you were carrying, what you were carrying. Is it properly licensed if a license is required? Did you obtain it legally? Those are going to be all the determinations as to whether the ATF decides to prosecute you federally, or if they turn it over to the state and just let the state prosecutors prosecute you. The amount of ammunition you have on you, your criminal history, all of those things. Keep that into consideration. So I thank everyone. I hope you guys have a great Friday Eve, a good Thursday night. It's Friday tomorrow, so we're all excited about that. I appreciate everybody, and I'll see you guys next week.